Hello friends, welcome to our channel Steno. Subscribe our channel for more dictations on daily basis. Get ready for the legal dictation. The learned single judge has dismissed the writ petition on 2 February 2016, holding that the charge of the appellant having consumed alcohol while on duty stood duly proved in the enquiry proceedings. The learned single judge found no merit in the submissions urged before him that the charge of intoxication could not have been established or proved unless a blood and urine examination had been performed. Before us, the learned counsel for the appellant has reiterated the above submission and has contended that the medical evidence which was gathered in the course of the enquiry was clearly inconclusive and could not have been formed the basis for holding the appellant guilty and his consequential termination. The incident itself is stated to have occurred on 23 July 2009 while the appellant was on security duty near the premises of a bank. He was found in a state of intoxication and taken for medical examination to a nearby hospital. A medical report was drawn up which recorded that he had consumed alcohol but was not intoxicated. On 24 July 2009, the appellant was suspended pending disciplinary proceedings initiated against him. He was subsequently charge-sheeted on 30 November 2009, whereafter a regular departmental enquiry was conducted in which the appellant was afforded an opportunity to adduce evidence and cross-examine witnesses. The enquiry report was submitted on 7 April 2010, and after taking into consideration the said report as also the response of the appellant thereto, the order of termination came to be passed on 7 May 2010. From a perusal of the order of termination, the enquiry report, and the material gathered in the departmental proceedings, it is apparent that on 23 July 2009, upon information being received that the appellant was in intoxicated state, he was immediately taken to a nearby hospital and subjected to a medical examination. More than one witness in the course of the enquiry proceedings corroborated the fact that the appellant was in a drunken state. The learned counsel, however, has contended that the charge could not have been held to be proved against the appellant unless he had been subjected to a blood and urine examination. We find that the learned single judge, while negativing the said submission, has placed reliance upon a judgment rendered by the Supreme Court in Samar Bahadur Singh vs. State of UP and others 2006 to SCC 161. Samar Bahadur Singh too was a constable in the police who was found in a state of intoxication while on duty and consequently dismissed from service. The medical report submitted in his case too recorded that he had consumed alcohol but was not intoxicated. The Supreme Court further refused to accept the submission made by the appellant before it that he had consumed certain medicines whose smell had led to the employer presuming that he had consumed alcohol. We may note that the appellant before us had also raised a similar defense before the fourth respondent that he had consumed homeopathic medicines.